Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, last week while we were all freaking out about Senate Bill 5078 and how it was passing out of the Senate and was going to potentially ban the magazine capacity that we have here in Washington State, we let something slip through the cracks, and we need to talk about it, and we need to talk about it right now because House Bill 1705 last week passed out of the House and is now before the Senate. So let's spend a few minutes today and talk about, is Washington State really going to ban 80% lowers? Okay, before we get rolling, you guys know the drill. If you like this video, click the like button down below. If you want to stay up to date on issues related to your Second Amendment rights, especially during this legislative session, click the subscribe button down below. Click the little bell logo if you want to be notified when we post new videos. And most importantly, again, when it comes to these legislative issues, let's keep the comments and discussions coming. This is how we're going to share our resources and ideas. And for those of you who are interested in combating this legislation, you really, really do need to form an alliance with as many lawful and responsible gun owners as humanly possible. Okay, so last week, as we know, all the news was about the passing of Senate Bill 5078 out of the state Senate, which is a high-capacity magazine restriction. And why we were all freaking out about that, unbeknownst to us, behind our back, the House passed House Bill 1705, and that now heads to the Senate for debate. It was passed out of the House on February 10th. It was given the first reading on the state Senate floor on February 12th, and this is where we sit today. Now, I'm going to spend a few minutes trying to get you to understand what House Bill 1705 does, because as you can see in typical Washington legislative fashion, there's about 16 pages to this bill, and hey, who's got time to read all of that, right? Well, I don't have a life, so I read it, but what we're going to do is we're going to try to break down this bill into short, small, little digestible pieces so that you guys can understand what this proposed legislation is going to do. And listen, this legislation can have a significant effect on your Second Amendment rights. So House Bill 1705 essentially does two major things. The first is it would outlaw 80% lowers. The second thing it would do is it would outlaw all untraceable firearms. So when we take a look at the proposed legislation, there is an amendment to RCW 9.41.190. For those of you who've been watching the channel, you know that's the statute that lists all the unlawful firearms. And then it would add two additional sections to Title 941, which for those of you who've been watching the channel, you know that's our firearms codes right there. And so I'm going to spend a couple minutes trying to get you to understand today what sections, if this was added to Title 941, what the new laws would read. Okay, the first of the two main issues that House Bill 1705 is addressing or attempting to address is the apparent scourge of violence that comes from untraceable firearms. Now, for those of us who've been watching the channel for a while, we know that RCW 9.41.190 lists all of the firearms that are unlawful in the state of Washington. And 941.190 subsection D actually refers to untraceable firearms. The statute as it's currently written today reads as follows. Except as otherwise provided in this section, it is unlawful for any person to manufacture an untraceable firearm with the intent to sell the untraceable firearm. So current restrictions is you cannot manufacture an untraceable firearm if your intent is to sell the untraceable firearm. If passed, House Bill 1705 amends 941.190 subsection D to read as follows. Except as otherwise provided in this section, it is unlawful for any person to manufacture, cause to be manufactured, assemble, or cause to be assembled an untraceable firearm with the intent to sell the untraceable firearm. And yes, there are new definitional sections that are being added to 941.010 as to what assembled mean. I'm not going to bore you with all of the details. I will put the link to the full text of the bill down below so you can see for yourself. So that's the first thing. But wait, there's more. In fact, much more significant legislation is proposed by House Bill 1705 as it relates to untraceable firearms. If passed, this bill would add a new section to RCW 9.41 with the beginning date, and this is important, of March 10th, 2023. If enacted into legislation, the new section of RCW 9.41 would read, 1. No person may manufacture, cause to be manufactured, assemble, or cause to be assembled an untraceable firearm. 2. After March 10, 2023, no person may knowingly or recklessly possess, transport, or receive an untraceable firearm unless the party processing, transporting, or receiving the untraceable firearm is a law enforcement agency or a federal firearms importer, federal firearms manufacturer, or federal firearms dealer. So, right now, we cannot manufacture a untraceable firearm with the intent to sell it. If passed, this legislation would make the possession, the mere possession of an untraceable firearm unlawful for everybody effective March 10, 2023. And unlike the proposed AR ban, there is not a similar grandfather clause in this particular legislation. In fact, there are very few exceptions to this legislation. The firearm is an antique. The firearm has been rendered inoperable. But the one that most likely would apply to you, the lawful and responsible gun owner, is the section in which reads, subsections 2 and 3 of the section do not apply to any firearm that D. has been imprinted by a federal firearms dealer or other federal licensee authorized to provide marking services as provided for in Section 6 of this Act. So the only way to maintain an untraceable firearm is to, of course, make it a traceable firearm under this legislation. Now, if you violate this law, how much trouble would you be in? Well, for a first offense, you would be assessed a civil penalty of $500. It's merely like a bad speeding ticket. However, if previously convicted and this is now your second offense, it is a misdemeanor, punishable by up to 90 days in jail and a $1,000 fine. If it is your second or subsequent offense because of 2 or more prior convictions, it would be a gross misdemeanor, punishable by up to 364 days in jail and a $5,000 fine. Now, the other area that House Bill 1705 wants to address is the dreaded 80% lower. And if passed, this bill would add yet another section to RCW 9.41, which would specifically address frames and receivers, as the legislation is calling it. The statute, if passed into law, would read as follows. After March 10, 2023, no person may knowingly or recklessly possess, transport, or receive an unfinished frame or receiver unless A. the party possessing, transporting, or receiving the unfinished frame or receiver is a law enforcement agency or federal firearms importer, federal firearms manufacturer, or federal firearms dealer, or B. the unfinished frame or receiver has been imprinted with a serial number issued by a federal firearms importer, manufacturer, or federal firearms dealer. So you may not receive or possess any 80% lower unless, of course, it has been stamped with a serial number, which probably makes it not an 80% lower anymore. But the statute goes on to further restrict unfinished frames and receivers, because subsection 2 of this proposed legislation would read, no person may sell, offer to sell, transfer, or purchase an unfinished frame or receiver unless A. the party purchasing the unfinished frame or receiver is a federal firearms importer, manufacturer, or dealer, or B. the unfinished frame or receiver has been imprinted with a serial number issued by a federal firearms importer, manufacturer, or dealer. And then, of course, to make this legislation possible, there are several amendments to RCW 9.41.010, which, for those of you who've been watching the channel, know that that's the definitional section of our firearms code. It includes a new definition of frames and receivers. I'm not going to bore you with the details here on this video, but again, I'm going to put the link to the entire text of that bill, House Bill 1705, down below. Check it out for yourself. So, like with Senate Bill 5078, which passed out of the Senate and now sits before the House, this bill has passed out of the House and now sits before the Senate, which means we have one final stand to make, and that is with the state Senate. What can you do if you are opposed to this legislation? Well, it's very simple. You need to contact your legislator immediately. You need to let them know that you oppose this legislation. Don't know who your state legislator is? Don't worry about it. We're going to put a link down below so you could find them. As always, make your comments polite, professional, well thought out. Make them worth reading. Listen, you may have more questions about House Bill 1705 or anything related to this legislative session or anything related to your Second Amendment rights for that matter. And if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.